My name is Erick Smith. A short time ago, we hosted free seminars and free range instruction at our nonprofit partner's beautiful campus, Camp Whitewood in Northeast Ohio. We also posted video of the event on our members-only webpage, including a presentation by a firearms expert on the subject of signage establishing no-gun zones, including to what degree and how those signs are enforced, and what penalties ensue for disobeying them. The information the expert provided resonated with the concealed carry community, and the responses we received were tremendous. We've all encountered the situation where we park our car in a store's parking lot, walk to the front door, and we're faced with the no gun zone sign, showing the image of a gun overlapped with a red circle and slashing line through it. So we stand there contemplating whether to go back to our car to put the gun in the glove box, or to just enter the store in the otherwise law-abiding manner we had planned, keeping our handgun concealed and secure, conducting our business, and departing without incident. Those of us who are extremely law-abiding and don't want to take the chance of losing our concealed carry permit trudge back to our car and take off our self-defense weapon and hope no one sees us leaving our handgun in the car. But very few concealed carry permit holders understand the law surrounding those signs that are posted on private businesses. We all know that Ohio law lists specific areas where we cannot carry our handguns. Those areas are detailed in Ohio Revised Code section 2923.126b, and they are as follows: a police station, sheriff's office, or state highway patrol station, a property of the Bureau of Criminal Investigations, corrections facilities and jails, airport terminals and airplanes, facilities for the care of the mentally ill, a courthouse or building containing a courtroom, any premises or open-air arena for which a D liquor permit has been issued, such as a bar, but only if you are consuming alcohol. You can carry your handgun into a bar as long as you have not been drinking and are not drinking at that establishment. Any premises owned or leased by any public or private college, university, or other institution of higher education. Any church, synagogue, mosque, or other place of worship, unless the place of worship posts or permits otherwise. A child daycare center, or a Type A family daycare home. Any building that is a government facility of this state, or a political subdivision of this state. There is no question about these areas. You can't carry your handgun into the locations we just listed. Some of those also include the parking lots of those facilities, including the BCI properties, school safety zones, unless you are picking up a child, any public or private college, university, or other institution of higher education, and detention facilities. Also, Ohio law has provisions for private businesses to prohibit concealed carry permit holders from carrying their handguns in their private establishments. If the owner posts a sign warning that firearms are not allowed in that building or property, then a different set of rules and laws applies. The law suggests that the following wording be used on the signs: unless otherwise authorized by law, pursuant to the Ohio Revised Code, no person shall knowingly possess, have under his control, convey, or attempt to convey a deadly handgun or dangerous ordnance onto these premises. But the wording is not mandatory. Section 2923.126 of the Ohio Revised Code addresses those issues. It is titled Duties of Licensed Individuals. Now, here is the information in our expert's lecture that stunned everyone. That statutory section tells us that if a person carrying a concealed firearm enters a business with a no guns allowed sign on their door, it is only a civil violation and not a criminal violation, until the person carrying the weapon is advised by the owner or other person in charge of the business or property to remove the weapon from the property. and the person carrying the weapon refuses to leave the property, the person carrying the weapon cannot be arrested. It is only after the person is instructed to remove the weapon from the property and that person then refuses that any criminal arrest can be made. The law states this: the owner or person in control of private land or premises may post a sign in a conspicuous location on that land or on those premises prohibiting persons from carrying firearms or concealed firearms on or onto that land or those premises. There are two key parts to take out of this code section. The first part is that the sign must be in a conspicuous location. It's fair to assume that conspicuous would be a sign that the average person would be forced to see upon entering a location. If the signage is hidden behind other items, or on a clear material that makes it hard to see, or on a door that opens and closes, then it may not be conspicuous enough. Think about this likely hypothetical. If a person in front of you opens the door to enter the store and they hold it open for you, and the sign is posted on the front of the door, you'll never see that sign as you enter the store. The second key part of this code, and what is causing a stir amongst our members, is that you must knowingly violate the rules stated in the sign. The store and subsequently the police and prosecutor must be able to prove that you knew you were not allowed to carry your weapon in the posted business. Although not required by the Ohio Revised Code, being verbally informed by a person with authority for the posted premises is the clearest example. Once you are informed of the business's ban on firearms, you must leave. Failure to comply is grounds for the crime of criminal trespass. You can ask if you can disarm and return to the store, and that decision is up to the business owner. If there is no sign posted and a person with authority tells you that firearms are not allowed, you must still leave and/or disarm at that point. In addition, if you live in an apartment building, the owner cannot prohibit you from having your firearm. Your apartment is your residence, and you can legally possess a gun in your own residence. The same rules apply to Section 8 housing. People visiting you, however, cannot carry a firearm in your apartment if the landlord prohibits firearms for visitors. Employers, on the other hand, can make up their own rules. Your employer can implement a rule that prohibits firearms on his or her property, including parking lots and company vehicles. You must comply with the wishes of your employer or you risk being fired from your job. Unfortunately, there are no standards set by the state governing the construction of the no-gun zone signs. There is no required size, color, or wording. The fact that the law states it should just be posted in a conspicuous place leaves a lot of leeway in posting that sign. And if you don't see it, you can't be charged for violating it.